Welcome to the GME Combined Lecture. I hope everybody can hear me. This is Julie Camp talking from Graduate Medical Education. We have with us today Christine Wirt, who is the Risk Coordinator for Hurley's Risk Management and Legal Services Department. She will be giving you the lowdown about risk management and an orientation to the basic legal services at Hurley, just so you're aware. It'll also help alleviate some anxiety and stress, we hope, because it's really common to run into issues, and once you know this information, you don't have to freak out or anything, hopefully. And after this, we don't have a post quiz yet, but if we get one, we will post it in the online classroom, and we will let you know when it's there. Once it's available, you'll have 4 weeks to complete it. Feel free to ask questions in the chat screen. I will be monitoring from a different computer from our presenter, Christine. And then you're also welcome to ask questions verbally. And then we will write up all the questions and answers and share them at the end as well. And we'll post the recording from this on the online classroom as well. And that's eGME. So without further ado, please welcome Christine Wirt to talk about risk management. Thank you.
Yeah. Hello, everyone. Thank you for coming in today or calling in or whatever the new norm is lately. I want to say happy Monday and happy New Year to everyone. Julie gave a perfect introduction because that is one of the main purposes of our department is to sometimes people, when they hear risk management or legal services, they do kind of freak out or they don't want to talk with us. And we really are a nice department. We're nice people. Some of the subjects that we talk about are kind of intensive, but we're always there. The one thing we want you to take away from this is that we are there to help you and to call us at any time you have any questions. So like Julie said, my name is Chris Wirt. I've worked here at Hurley 4 years now. It's coming on 4 years in just a few days. Before that, I worked at another healthcare facility in risk management for quite a while. I hate to say how long because then I'll age myself, but over 10 years, I'll say that. How's that? So we'll go ahead and start. And I apologize, Mike Clark is not able to be here today, but we do have the information that he was going to provide. And if there's any questions that I'm unable to answer, we'll go ahead and answer at a later time. Okay, some of the topics we're going to talk about today, and these are just general topics. Feel free at any time to ask any questions, or if there's a topic that we're not covering that you would like to discuss, feel free to interrupt me at any time. So some of the topics we're going to talk about are surrogate decision makers, some questions, general questions about guardianships, durable power of attorney, informed consents. We're going to touch a little bit on research and give an overview of our legal and risk services. And we're also going to talk about incident reports and safety huddles. And then we'll touch a little bit on lawsuits, just enough to get you some information, but not to scare you. Okay, so this question, I assume we get a lot of calls on this question, so I'm sure in your practice it comes up quite a bit. Decision makers. Hurley, with the patients that we see at Hurley, sometimes they're either incapable of making their own decisions or they're brought in without the capacity to make the decision. So the question is, who's going to make the decision for the patient? Of course, the first option is the patient. If the patient is capable, then the patient is the one and only person that can make the decisions for themselves. Capacity, we have all kinds of policies on this on our Hurley Internet, but to determine capacity, it is the medical care provider decision to determine if the patient is capable of making their own decisions. If there's any questions, they can always get a second opinion from another care provider, or as long as it's documented in the medical record. So if the patient is deemed incapable of making their own decisions, what do we do now? Unfortunately, Michigan does not have a family consent law, so it is not spelled out legally as to who can make the decision for the patient if they're not able to. So what Hurley has done, they've advised with different attorneys, different out-of-state attorneys to see what other states do, and we pretty much follow the guidelines that's followed throughout the United States. So of course, as I said, the first order is the patient. The patient will be the one making their decisions. If for some reason the patient is not able to, then hopefully, best case scenario, they have a durable power of attorney for healthcare. That's best case scenario. I'm not saying that's 100%. That's usually more like 10% of our patients, unfortunately. If there is a durable power of attorney, then that person designated in that document would be the one making the decision. If there's any questions about the durable power of attorney, like is it valid, is it from another state, please feel free to contact us. As long as it's in the record, we can look it over, check it out, make sure that it's valid and good to go. The next choice is a guardian, a court-appointed guardian. Sometimes our patients will come in and they have a guardian. So we need to obtain a copy of the guardian's documents and look to verify to make sure that this is the person that is here to make the decisions. Again, that is not something that you need to do. Just give us a call. As long as they're copied into the record, we can go ahead and look at them and make sure that they're valid. If they're in Genesee County, we also have a website that we go to just to make sure that they're in good standing and they haven't expired. A lot of times too, the patients while they're here, if they are not going to get better, then we do advise the family members to go for the guardianship process through the courts. If none of these documents are available and the patient has not made prior plans, we go by the, it's not part of a law, like I said, but it's part of a standard. So the first person that would make the decision is a spouse. This has to be a married spouse. I mean, it's not a divorced spouse. It's not someone that's separated. As long as if it's, for instance, in case of adult abuse and the spouse is suspected, then of course you would contact our department and we would determine if it was appropriate for the spouse to be making decisions. After that, the adult children, and this is where it gets sticky. It cannot be one adult child. It has to be all of the adult children. So if the patient has 10 children, a good attempt has to be made to contact all 10 children. Even if the child is incarcerated or the child of the patient is incarcerated in jail, we still have to make an attempt to contact all the children. Now they can designate and say one person is going to be the decision makers, and as long as all the children are agreeable to that, that's the best case scenario in that case. And if there are no adult children, then both parents. It cannot be just the mom or just the dad. It has to be both parents that are contacted and provide the decisions. And then after that, all siblings, which again is the same case as with the children. It has to be all the siblings, not just one, unless, of course, you contact a sibling and they state that, no, we don't want to be involved with the care of this patient. And in that case, we just go with the person who's willing to help us. This is a process. You alone are not responsible for determining this. You can reach out for help through our department. You can reach out to case management. They're really good at tracking down adult relatives and things like that. So, but they might need your help with all this. Questions, I'm assuming? I asked Julie if she could do some cardboard cutouts of people in here just so I could pretend if I was working, like they do in the sports on the TV, but we'll see if that works. So informed consent for the people for the decision making. The informed consent is very important, as I'm sure you already know, for a couple of different reasons. If you don't obtain informed consent, you can be charged with a crime. Basically, the informed consent is to prevent you against medical malpractice. If the information is not disclosed to the patient, if the patient does not, or the patient or the designee does not provide informed consent, and we go ahead and perform a procedure or don't perform a procedure, then we are liable for the medical malpractice. So it is the duty of the physician to inform the patient or the decision maker of the risks of the procedure. It's not the responsibility of the hospital or the clinical staff. It's the physician discussion that needs to happen for the informed consent. And the key question to ask, in criminal or medical malpractice is, would the patient have consented if they were able to or not consented? Of course, we're legal and risk management, so we have lots of standard practices. If you want to review the informed consent standard practice, it's 0214. And I basically have already said, why do we need informed consent? Patient has the right to decide. It's an ethical duty on the part of the physician. It could result in a criminal matter if consent form is not obtained. It also is a requirement of the Joint Commission and the Medicare conditions of participation. So when it conforms consent, what exactly is it? Informed consent is a process. It's a process of a discussion. It's not just signing the paper and say, here, you provided informed consent. It's a dialogue about the proposed treatment or testing. It's a dialogue about the nature, the consequences, the risks and the benefits, and the alternatives. And it's very important that you document in the medical record that you had the informed consent discussion with the patient or the decision maker. So basically your role is confirming that you had a conversation rather than just getting a piece of paper signed. And I'll talk a little bit later about the different types of informed consent. A good informed consent discussion will include discussion of the diagnosis, of course, disclose what the patient is being diagnosed with or what the potential diagnosis is. The name of the procedure, discuss that closely with the patient or the decision maker. Try to, I don't want to say dumb it down, but try to, speak to the level of the patients. Don't use the medical jargon that they might not understand. Explain the risks, the complications. In your notes, we ask that you not just say we explain the risks and the benefits and the alternatives. We ask that you provide a few of them, not all of them, of course, because then you would be documenting forever. Be like those commercials with the medication that list all the complications that could possibly have. We're not asking for that type of detail. We're just asking for a high-level overview of the risks and the benefits and the alternatives that were discussed. You could document, information that you talked with them about what might happen after recovery, what kind of success rate there is, if that can be provided at all. And also include the name of the physician or anyone involved with the test or the procedure. And then, of course, with your documentation, you will have your name as being the person who explained the risks and the benefits. And at that time, the physician is more than welcome to have the printed out consent form signed. They also can go to the staff and ask, we've talked with them, go ahead and have them sign the informed consent. As long as that discussion has been held with the care provider, then the informed consent can be attained. The actual paper document with the signature can be attained by the clinical nursing staff. I'm sure you've all seen some of the printed informed consents that we have. They're pretty standard. We're trying to standardize them all so that they have the name and signature of the patient or the legal representative. We also have the date and time signed. It's very important for legal reasons to have the time. You might think it's kind of, okay, we have the date, why do we need the time? Well, if they signed it at 2 o'clock in the afternoon, but the procedure was at 9 o'clock in the morning, that would raise a red flag. So as long as we have the date and time documented, and then also the nursing staff or the physician has to witness the signature to make sure it was the patient or the provider giving the correct signature. Okay. With the informed consent discussion, only someone who's qualified to perform the procedure is capable of sharing the risk and the benefits. If someone that is not involved in the procedure, someone that has never performed the procedure, they might not know all the details and everything, which is why we ask that the clinical staff, the RNs, do not have the informed consent discussion with the patient or the care provider. We ask that it's someone that actually knows what is going, exact details of the procedure and the definite risk and can answer the questions appropriately that the patient might have. The person who had the discussion with the patient should be the one documenting in the medical record. It's kind of hard, like even if I'm witnessing someone having the informed consent discussion, it has to be the person that had the discussion that documents in the medical chart. So like I said, it could be in the progress notes, H&P, the office notes, but it must be in the chart before the procedure is completed. So before the procedure testing is done, they have to have the documentation, the notes in the chart that the discussion was held, and they also have to have the paper signed copy of the informed consent, but of course, unless it's an emergency. Some organizations require that the person who had the discussion sign the consent form. We don't do that at Hurley here. We are cognizant of the time that this takes and appreciate all your effort. So as long as it's documented in the chart that the care provider did have the discussion, then the nursing staff are able to actually get the physical paper copy signed. Okay, more on consent. I told you this is going to be a really important topic. There's several types of consent. Implied consent is like, such as if you're going in for a blood draw and you just stick your arm out and you're thinking, oh, okay, this patient consented. Well, no, that's not an accepted practice. Just because they stick out their arm doesn't mean that they understand what is being done or what it's being done for. So that's why we ask that you do get the signed consent form, not just an implied consent. And of course, there's the emergency exception. If it's in the physician's judgment that it's unpractical or you cannot, impossible to obtain informed consent, and serious harm might happen if you wait, then an emergency exception is always available. And we like to clarify that not just because it's in the emergency department doesn't mean it falls under emergency exception. It has to be an actual physical emergency that will cause harm if the patient is not treated immediately. A lot of these come up like if we don't know the patient's DNR status and they come into the emergency department. Our motto is always to err on the side of life. If you don't know the DNR status, then treat them as you would every other patient until that can be determined. Refusal, this comes up more often than what we care to admit, but there are some situations where the patients refuse. They do not want any more testing. They don't want any more treatment. And no matter what you as a caregiver feel, like you know it would be valuable, you know it would help their quality of life. If the patients want to make a bad choice, then they, as long as they have the capacity, they have the right to make that choice, whether it goes against our better judgment. They can refuse treatment, even if it will result in their death. And the emergency consent can only occur when you have the belief that the patient, if they consented, would decline. So that's the emergency exception. And we can't, unfortunately, like we say in the TV dramas, if the patient has refused treatment before and then for some reason they become unconscious or they're unable to make any more decisions, we cannot override the decision that they previously refused. If they refused earlier and their designated person also is refusing, we cannot override them just because they aren't able to discuss any longer. There is an option because this is a difficult situation. We do have an ethics committee here at Hurley Medical Center, which they have staff. We have physicians, nurses, we have community individuals, we have a legal representative on the ethics committee that are on call. So we do have that option if you feel like if maybe the patient is making an incorrect decision for some reason, or if their guardian or designated decision maker is not quite understanding everything, or they need some help, there's an option to present an ethics referral. That is an EPIC order. You can place the ethics referral through the EPIC, or you can also call or fax the patient advocate with the information, and that will go ahead and give the on-call team. Usually they respond, they investigate, and they respond to everything within 24 hours. Okay, how can we improve the informed consent? That's the part of the risk management. We're always looking at ways to improve. Kind of a synopsis, stop referring to the consent as getting the patient's signature on the form. It's not just a signature on the form, it's actually a discussion with the patient and their care provider. Use less legal and medical jargon. We've tried especially with the surgical informed consents that we have, we tried to remove the legal jargon and make it as understandable as possible. Please list all the specific risks and alternatives. Like I said, can't list all 100 of them, but you can, list the majority of them or the major ones that were discussed. You can also document any questions the patient might have had and say that, this answer was provided, as far as I know, to the satisfaction of the patient. You have written materials, please provide them as educational material. Any aids or videos, which might improve understanding, that would help. And like I said before, document any questions or answers to support that the patient did understand. Good so far? No questions? Okay. Hopefully everybody's still awake. This is another issue that comes up frequently with the type of patient population that we see, consent of minors. The general rule is until a child is 18 years, then the consent needs to be obtained from the parent or the guardian of the child until they're 18 years old. Once they're 18, they're considered adult. There are some special exclusions to this, such as prenatal care, some sexual transmitted diseases, and mental health, which are some exceptions, but those are minor exceptions. And then for pregnancy, the patient must be notified that the father or the patient's parents may be notified. One of the clarifications we would like to make, because we do get this question a lot, is a pregnancy and a birth does not make the patient emancipated. We'll get a call, occasionally, well, this 15-year-old had a baby a year ago, so that means that she doesn't need any more adult signatures. Well, that's incorrect. Just because a minor has a baby does not mean they're emancipated. To get emancipation, they would have to actually go through the court and provide papers. So this is where it gets confusing. A patient who is a minor patient who is pregnant or has a baby is able to provide consent for anything pregnancy related or anything related to the baby. So if you're 14 years old, you've had a baby, or you are going to have a baby, you can consent to your pregnancy related testing and procedures, and you can't, after the birth of the baby, you consent for the baby's care. However, if the 14-year-old needs care, if they need something medical, such as tonsils removed or appendix removed, the father or the mother or the guardian has to make the decision. So you potentially have a 14-year-old that can make decisions for the baby, but cannot make decisions for herself. And again, any questions, give us a call at any time. If you need, call, weekends or nights, you can call the operator, and they do have the number for the attorney that can help if something major comes up and we're not here in the office. So temporary guardian, sometimes we have children in here whose parents are unable physically to come in and provide consent. If the parents are out of town, if they're out of state, if they live in a different location, if they are incarcerated, they can sign documentation, and there's an example of it on the Risk Legal Services webpage that will give temporary custody, temporary delegation powers to another person. Basically, typically what we see is if the parent is going to be away for a length of time, they will sign over, say, okay, the grandparents of the child can make these decisions in my absence. You can get these off the internet too, so they're very confusing. If you have any questions, if anybody brings this to you, go ahead and give us a call. We'll have the attorney look through it, make sure it's valid. They're only good for 6 months. At the end of 6 months, that parent has to re-sign another paper. The jails typically are very helpful in working with us, and these papers, they have the documents there. They have access to the parents, and they will get the signatures and fax the information to us. But this does come up even occasionally. Okay, that's enough on informed consent. That's just a brief overall. Like I said, every case is different. Every question is different. You would think after being in risk management as long, we'd know all the questions, but something always pops up that's different. So please feel free to give us a call anytime and ask us any questions. And so leaving against medical advice. I'm sure you've heard there is a policy out there, of course. It's Standard Practice 0291. It's listed on a further slide so that you will be able to look up later if you would like. But Teresa Bork from Nursing Administration has been working very hard on this policy. If you've seen the teal gowns that we have, so we see that the patients that are elopement risk, so to prevent elopement, we're trying very hard to do that. We ask the providers, some things you cannot, if a patient wants to leave and everybody has talked to them, there's some things some people you just can't keep here. They don't want to be here and they're not going to stay here. So we try to provide a safe discharge for them. We document like crazy, and we have the patient sign that they're leaving against medical advice, but we still set up any appointments they need. We still provide the medical equipment, the prescriptions, everything that they would normally receive on an appropriate discharge. It's just that the patient has signed the against medical advice, but we do have a responsibility to provide them with safe follow-up, even though they've chosen to leave. There is, on the next slide, you'll see it, there is some patients that we cannot allow to leave against medical advice, such as minors. Of course, they are not allowed to leave against medical advice. We also have patients that have been petitioned and certified, or patients that are not able to make their own decisions. They're not able to leave against medical advice. We provide training, public safety, and then nursing also provide training, de-escalation training, to help you assist in the conversations that you have trying to de-escalate these types of situations. And then they also provide sitter and safety observations to education to those people that sit with the patients to try to help de-escalate that. Attached to the slide, I'm not really going to go through it in detail because it's really hard to read, but it is included in the standard practice 0291. It does list specifically what to do for patient types. Any adult minor patients admitted for suicide attempts, of course, are not able to leave, but any patient type 1, 2, and 3 are not allowed to leave, and we are empowered to contact public safety for assistance to keep them here. Okay, a little bit, I'm sure, especially the residents are working with research projects. So the Risk and Legal Services, Mike does work with the IRB, Institutional Review Board. Any research that is being done must be reviewed and approved or exempted through the IRB. This is an FDA requirement. And these are just some of the standard practices that are listed out on the internet. You can go ahead and go review them if you would like at your convenience. But basically the takeaway here is that any research needs to go through the IRB before it can be approved. Research, there is a policy in there that explains the difference between research and quality. If you have any questions, it's best to contact the IRB and they will determine if it does need IRB review or if it can be exempted. They will give you letters say this is exempt from IRB review. This is very important because if you do start a project and you think quality doesn't need IRB review, I'll go ahead and do this. But if you go to publish or to anything with the information that you did receive, if you don't have IRB approval, then it will not, the publications will not accept it and you will not be able to publish it without the IRB review. And it's definitely harder to get IRB approval after you've done the research than before. So my suggestion is to contact the IRB or the scientific review committee at the beginning of the project just to get everything straight before you start. Okay, I talked a little bit about legal and risk services, but just to get a little bit more in detail, we have 2 attorneys on staff. We have Peter Bade, who is a staff attorney. He has been here longer than I have been. I'm not quite sure how long he's been here, probably about 8 years. But Pete works with the workers' compensation, with the employment, lawsuits, legal actions, things like that with the unions. We also have Michael Clark, who unfortunately couldn't be here today, but Mike works with the medical malpractice claims, with the contracts, anything with the informed consent questions or anything that we have questions on, Mike will work with those. We have Tracy Miller, who is our paralegal. She works mostly with the contracts, and she also provides notary services. So if you do need something notarized, as long as it's nothing financial, Tracy can provide the notary services for you. And she's usually in the office Monday through Friday, 8 to 4:30. Our contact number, just call our general line at 29045 at any time with questions. And that's my number, so I'll guide you to the correct person, whoever you need to talk with, or if I'm able to answer your questions, we'll take care of that. We also have a risk and legal services webpage on the Hurley Internet that has some standard practices. It has a couple of our educational presentations that we used to do before COVID, when we were able to do them in person. And we have the slides and questions about that. So if you're looking for further information, that's on there also. I guess the takeaway I want you to take away from this is that we are accessible, we are friendly, and we have chocolate in our office. So feel free to come down and see us at any time. I'm going to talk a little bit about the SHARE system, the significant event reporting system. It's called the SHARE system, but the initials actually stand for Staff Help All by Reporting Events. And if you were in this room, usually this is the point where I would ask you to raise your hands if you've heard about this. I'm going to be optimistic and say like at least half of you have heard about this, hopefully. But this is an electronic system that we use to report any patient safety related events. So before we start, I'll explain exactly how to enter an event, but I want to reassure you that it is peer review protected, and it is part of the Patient Safety Organization protection, which is another legal protection through the state of Michigan. So basically what that means is that whatever you enter into the share system is not subject to legal scrutiny. An attorney for the patient cannot say, I know you have an event reported, I want a copy of it. It's legally protected. Whatever's in that event system is not able to be given to outside legal representation. It's for our internal quality purposes only. So that's the safety. It is not part of the medical record, and it is confidential. We ask that you report any type of events, patient safety events, patient falls, medication errors, IV infiltrates, things like that. And we ask that you report it even if it doesn't reach the patient, but it has the potential to cause harm. Because you might think that, okay, it didn't reach the patient, no harm, no foul, but it could escalate. You know, how many near misses do you have to have before it actually does reach the patient? So if we're notified that there is a near miss, that something did potentially happen, we can look at the process before it reaches the patient and prevent it from harming any future patients. What happens when you enter a share is that I review them daily. So I do see them every day. Also, you choose a department that's involved. So the leader of that department will review them also. The individual department leader is responsible to investigate, follow up, and provide feedback within 5 days. So you also, by entering the share, you have the potential to go back into that system. We'll look at what the follow-up was provided and answer any questions that you might have had. It also gets a weekly review by senior leadership team. We call it the Culture of Safety team. Dr. Yagi's on that team, along with a couple of the nursing directors and the quality director and myself, to review the events to see if we can identify any major trends, anything that we need to hold together a group to discuss. It also is reported up through the Quality and Patient Safety and Board Quality Committee. If we do feel that it is a major issue or something that we can help with, we do initiate what's called the root cause analysis process, and you as physicians and caregivers might be asked to participate in this process. In this process, we pull together a group of experienced personnel. It doesn't have to be necessarily the people that were involved in the event, but it's people that have the knowledge that we can look at the process, look at it, and see what can Hurley do as an organization to improve the process. Is there better equipment, better staffing, something that we can do to improve the process? We don't necessarily look at an individual action. If it was an event that involved individual mistake, individual intent, then that is processed through the Human Resources Department or medical staff peer review. Purpose, like I said, basically just to notify us that something did happen. It is confidential. It's also notifies us if there's potential litigation, if there's something out there that we think the patient is going to sue us on. It gets us able to go ahead and get ahead of it and do some investigation before we're confronted with it. Oh dear, I didn't know I did this. If there is an injury, it is the responsibility to stabilize, of course, the injured person, and this also refers to visitors too. Back in the day when we had a lot of visitors before COVID, if we had a visitor fall, then this is the mechanism to report these types of incidents in addition to public safety. So we want to ensure that no further injury is going to occur, make sure the patient is safe and treated before we go ahead and report the incident. The first employee or physician on the scene or witness to the incident is responsible for completing the incident report. If in doubt, enter it anyway. It doesn't matter. I'd rather get 5 reports than none. So even if you think somebody else might have entered it, please go ahead and enter it again. It's not a time-consuming process. We've timed it. We've had people that are not familiar with the system, and it takes anywhere from 2 to 4 minutes at the max to enter this. We have links in the system that will go ahead and link you into the medical records, so you don't have to provide anything other than the medical record number of the patient, and then basically a few clicks and then the comments as to what exactly happened, and you're done. Once an incident report is entered through the share system, any further investigation is undertaken under the direction of risk management or legal. You don't have to do any further investigation unless we reach out to you and ask you. Sometimes the managers will call you and ask you for additional information, discussion, questions, suggestions that you might have to improve the process. We ask that you don't file or reference the incident report in the medical record, because what happens if you write in there and wrote an incident report, if the patient gets request a copy of the medical record, they see that document in there, they say, okay, something horrible happened, I need a copy of the incident report, and then they get very irate when they're not allowed to get a copy of the incident report. However, the facts of the event must be documented in the medical record just as normal. So if a patient fell out of bed, that would be documented in the medical record. Any treatment, any test, and everything would be documented in the medical record. But in addition, it would be filed through the share system so that the administration can look at it as a process to see what can be done to prevent it from happening again. In addition, we use the same system to report any job-related incidents within, it's called workforce safety. So for yourself, if you happen to fall, if you happen to get a needle stick or get an exposure to blood or something like that, we ask that you also report it through the system. Sorry, it comes back up here. There is a section, you do get to pick patient safety or workforce safety. It's very important that you yourself enter the workforce safety for anything, because that will allow occupational health to follow up with you. Also, if it requires any additional testing or procedures, it ensures that you are not billed for them. So it's very important that you go ahead and enter those into that system. So we ask you as a healthcare provider, please learn to recognize the near misses. Those are just as important as the actual events that occur. Look for them in any processes that you're involved in. Don't accept it as just a one-time mistake. Don't assume that they're individual. Say, okay, it just happened on this floor. It could be happening in other units throughout the hospital, but we're not aware of it because nobody is reporting them. So please go ahead and enter anything. The system, here's the Hurley Intranet. If you look on the right-hand side, about halfway down, it says Share Incident Reporting. That's what you click on to go ahead and get into that system. As long as you are signed into a Hurley computer with your Hurley sign-on, there's no additional sign-on. You just click on that link and you're brought right to it. So there's no confusion. This is where it says Event Reporting for Patient Safety, and then Workforce Safety if it does involve yourself. Really quick screen. This is basically what it is. Like I said, 2 minutes, please, at the most. These are just a couple of funny slides. I had to add these in. Some of them are making fun of the attorney, so with his permission, they're in here. They just give you a good laugh. Another thing that the risk management works with is national patient safety goals. So we do work with the patient safety goals that are established every year. As part of that, we work with the safety huddle, which I'm hoping that you have had the opportunity to discuss. And then we also have team steps, de-escalation training, which we mentioned before. And then we ask that you have safety as a priority. Please feel free to stop, ask questions at any time, get any questions resolved, or if not further, please go up the chain of command and get the questions that you need resolved. The safety huddles are Monday through Friday, 8:45 a.m. to 9 a.m. Typically, they're held in the 8th floor rotunda, but currently, because of the COVID precautions, it is a virtual call. If you need that call-in information, please just let me know or contact Julie Moses from Quality and Patient Safety. She also has the information. It's a Google call. You can call in from your telephone. You can call in from your computer. At the most, it takes 15 minutes. Dr. Yagi usually leads the calls, and we keep it short and sweet, basically. The purpose is to get real-time discussions of any patient's or staff safety concerns. It's not just related to patient. It is related to staff safety also. Everyone within Hurley are welcome to attend. In order to get on the call, you do have to be a Hurley employee. We have had sometimes with the phishing scams, we've had people from like the media try to get into these calls, but it is for Hurley employees or medical staff only. In addition, all units and departments conduct their own safety huddles. And basically what they talk about, what happened yesterday, what can the hospital learn from it, what's happening today, how can we prepare for it, like, do we have enough supplies, do we have enough equipment, things like that. And then general hospital updates. And then, of course, right now with the current climate, it's all about COVID and the vaccine. So you get a lot of information through that call. So I do encourage you all to go ahead and call into that at least once a week. If not, we do take notes daily, so you are able to access the notes. If for some reason you're on an off shift or not working that day, you can access the notes when you come back to work. Okay, on to the fun legal stuff. Subpoenas. This is what everyone is scared about. Me get a subpoena. It's quite scary. Criminal, there's two types of subpoenas that you could receive. Criminal ones, most commonly, they're out of patients that present through the emergency department. If they've been a victim of abuse or if they've been caught doing something illegal and they're injured and have to be come into the emergency department. If the courts are pursuing a criminal case against the patient, they might look at the medical records, see you as a provider, and subpoena you. So it could come from police, could come from courts or defense attorneys. Record review is not required at that time. Basically, the attorney will tell you exactly why they are subpoenaing you and what they want you to testify on. If they do want you to review a record, they will provide it to you. It's nothing that you have to do on your own. And I want to say first thing, I know it's addressed later in there, but I think it needs to be addressed now, is any subpoenas that you receive should be coming from either from myself, Tracy, or the paralegal, Tracy Miller. We have worked with the local police. We have worked with the local court systems. They do provide all subpoenas to us so that you will not be tracked down on your personal time or you will not be bothered at work. We will accept the subpoenas on your behalf and then send them to you along with our contact information to answer any questions that you might have. The second type of subpoena is a civil subpoena. So if somebody's suing their auto insurance company and you treated the patient as a result of their auto accident, they might subpoena you. Any professional liability, if they feel that they need to go to court and sue Hurley for some reason, you'll get a subpoena. Or any guardianship issues for mental capacity. But again, those subpoenas all come through our department. If you receive a subpoena that is not from our department, my best advice is to call us right away because it might not be valid or you might not have to respond to it. So it's always good to call our department. We'll have the attorney look at it, see if it's valid, and see what we can do to help you. Basically, when you do get a subpoena, like I said, notify your program director right away. If the subpoena is not through our department, received through our department, contact us right away. If you have insurance with outside of the Hurley Medical Center, if you have your professional malpractice insurance outside of Hurley, please contact your insurance provider. Don't have any discussions with parties that aren't involved in the case, and cooperation will contact you. If you do receive a subpoena, then, like I said, we will work for you and answer your questions and help you through the process. A lawsuit, this is the word that is not the best word in the English language, but the process for a lawsuit, basically the first step is notice of intent. That basically what I explain it as from a non-attorney standpoint is basically the patient is thinking about suing us. At this point, the patient's attorney has gone through the medical record, obtained every single name of every single person who had contact with the patient and usually provided a notice of intent to them. Case in point, we had a notice of intent served on us right before Christmas. I had 52 copies. That was very busy trying to get a hold of 52 individuals, but basically the attorney will go through every single name down to the unit secretary that was involved. The names in the record, then some attorneys will provide a notice of intent. Those all come through our department also. Sometimes you are served personally, either through certified mail. We receive a copy also, so we will reach out to you, but then we also ask that you, if we do not contact you, to reach out to us too, just to let us know that you did get this notice of intent, so we can notify our insurance carrier also. Next one is a complaint, which basically means that, sorry, these are in later slides. Summons to complaint is notification of an official lawsuit. So basically the people have done the notice of intent. They've decided that, yes, I am going to go on and sue this patient or sue Hurley Medical Center for some reason. basically with those, the summons have less people named. So if you did get a notice of intent, it's not surprisingly if you don't get a summons and complaint, they might say, okay, you as a care provider weren't really that involved, so we're just going to drop you from the suit. And the length of time between this, it always was lengthy, but even now with the COVID, with the court restriction, things like that, it could be years. We could get a notice of intent and you might not hear anything for a year. So don't be surprised if you don't hear anything. Also, if they decide not to sue, the notice of intent just expires and you will never hear anything from them again. That's the best case scenario. So after a summons and complaint is received, we go into discovery mode. We have our assigned attorney outside of the Hurley Medical Center that we work with to represent us and the Hurley Medical Center employees. They also require us to do mediation, which is basically try to get together and talk it out before we sue. And if not, then it does go to trial. If it does go to a deposition, if it goes further where it's going to look like it is going to go into a lawsuit, either our Hurley Medical Center attorney or the defense attorney will schedule a deposition. We will notify you at the time that our attorney is going to contact you. Our attorney, we contract with several attorneys outside of the Flint area, or in the Flint area, but outside of Hurley Medical Center, that do represent us in trials or legal cases. So if this is an option where they do need a deposition, they do need to meet with you, our office, myself, will contact you first and let you know this is the attorney, this is his name, his or her name, this is their assistant. They will be calling you to set up an appointment. And typically, if it's only one or two people, then we do have a legal conference room that you can meet right on site. They come to you to talk with you at your convenience according to your schedule. So please make sure that it is according, we do ask you to work with them and work in a timely manner, but they do work well with your schedules. So, and anything will be coordinated through our office. So if you do get a call from an attorney's office that you're not familiar with, you didn't know they were going to call you, please don't provide them any information and just give us a call and we'll let you know if it's okay to talk with them, because we have had other attorneys go ahead and call and try to get information out of you when they shouldn't be. Basically, during the deposition, this is just basic, some questions. The attorney that we work with will work through you. They have a pre-deposition meeting. They will work with you, tell you exactly what to expect, how to work through it, and how they're going to be there to help you. So takeaways, basically, don't discuss any legal matters with anyone outside of the case or your insurance carrier. We provide support for informal legal matters, formal legal matters. If you have any questions, give us a call. If it's your first notice of intent, we'll set up a meeting with you if you'd like to talk with Mike and just go through the process a little bit. And we do ask for your cooperation. And you're never alone. We're always here to help you. Basically, the next things are, again, some questions. Making funny remarks about attorneys. We have to make fun of them a little bit just so they don't take themselves so seriously. But that is the end of the presentation. So were there any questions? You gotta do, some of these are funny. I mean, I did check with Mike before I left him in here and he did agree to them. So yeah. Sometimes lawyers ask silly questions. Yeah. Hi, thank you for your attention, and feel free, access the website. We have some information on there, and give us a call at any time at 29045.
Thank you very much, Chris. We really appreciate it.
Julie.
And if you think of any questions afterward, just you can email me or Chris, and we'll write up a Q&A list and send it to everybody after the fact. I guess my only question are, for resident physicians, what are some of the most common questions that you get throughout the years from them? Is it mostly related to a deposition or something else?
No. Thankfully, deposition is worst case scenario. That doesn't happen too often, as often as you would think. A lot of the questions that we get generically are like the guardianship. How do I know who can make the decision? What the minors with the consent. That's a lot of the questions that we get from risk management and disruptive patients, disruptive visitors. We get a lot of concerns about that. We get a lot of requests to review the guardianship papers to make sure they're legal, make sure they're adequate. Sometimes there's family infighting that we try to not get involved in, but try to help the residents through. And then a lot of the questions too on notice of intent. If a resident will get a notice of intent, I don't know why, but the defense attorney or the attorneys for the patients love to involve the residents in the notice of intent. And I'm like, you want to say, people, leave the residents out of it, but they do get the notice of intent, and we walk them through that. And like I said, Mike is more than willing to meet with them to talk with the process, go over the notice of intent with them and explain the process to them, and not to be worried that, you are a Hurley Medical Center resident, you do have your malpractice insurance through Hurley Medical Center, and we do have legal representation for you.
Oh, cool.
Even after you've graduated the program, if the notice of intent comes in, we contact you, and it's still same as if you're on site. If it happened while you're here during your residency, then we have your back.
That's good to know. That's great. Well, thank you very much. So if anybody has any questions, you will be the first person they call.
Oh, yes, thank you. The champagne.
Oh, champagne. Happy New Year, everyone. Thank you so much. We hope everybody has a happy and healthy day. Thank you.